So a case is up for Supreme Court review which deals with whether or not the federal law prohibiting nonviolent felons from possessing ammunition and firearms is in fact unconstitutional. So let's talk about this. But real quick before we jump into this important case, if you think it's time for the Supreme Court to once again take up a two-way case, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn the skills and techniques they'll need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more about SDI, you can visit them using the link down below. As I mentioned in the intro, in this video we will be talking about a case which is currently seeking Supreme Court review. This case involves whether the federal prohibition on possessing ammunition is valid under the Commerce Clause. The plaintiff in this case is challenging whether Congress may criminalize intrastate possession, or possession that only happens within a state, of ammunition solely because it crossed state lines at some point before it came into that person's possession. This is an important case not just because it impacts federal prohibitions on felons in possession of ammunition, but it could also impact the federal prohibitions of individuals in possession of firearms as well, and also many other federal prohibitions that have the Commerce Clause as their underpinning in their foundation. Now, the facts around this case are absurd but also very interesting. Mr. Seekins was arrested on the suspicion of stealing a U-Haul back in 2019. Mr. Seekins was homeless at the time of his arrest, and he survived by collecting things out of the trash, and then he stored them in the U-Haul truck, which he was also sleeping in. When the police searched Mr. Seekins in the U-Haul, they found multiple flashlights, cell phones, a lighter, a spyglass, and one orange 12-gauge shotgun shell was also within the U-Haul. When asked why he had the shotgun shell, he said that he found it within a trash can. The shell in Mr. Seekins' possession also almost looked identical to a flare gun shell, which the officers initially identified as a flare gun kind of shell, and they pretty much just wrote it off as something that would be used in that flare gun. Because also within that cluttered U-Haul, they found other items like wrenches, tools, jumper cables, and then they also found a flare launcher, so they assumed that that shell was for the flare launcher. Inside the flare launcher was another shotgun shell, and later the police found out that the flare launcher had been modified to potentially accept and shoot a shotgun shell. Mr. Seekins alleged that he found the flare launcher in a dumpster, and there's no evidence to the contrary or that he modified that flare launcher on his own. But because he had prior felony convictions, Mr. Seekins was initially charged with possession of a firearm under 18 U.S.C. section 922G. However, in the lawsuit, Mr. Seekins' defense gave notice of a proposed expert testimony showing that the modification of the flare launcher did not meet the federal definition of a firearm. Now, in response to that defense, the government then abandoned their initial charge of possession of a firearm by a felon and then changed it to possession of ammunition by a felon. And importantly for this case, the record contains no evidence that there was a commercial transaction of any kind involving the two shotgun shells that were found, nor is there any evidence that shows that that shotgun shell traveled across state lines and eventually wound up in Mr. Seekins' possession. And it made no effort to show when, where, or how they potentially crossed state lines. The government simply presented a witness only to show that the company that manufactured these two shells most likely did so in the state of Illinois. And as a result of the changing of those charges, Mr. Seekins was sentenced to 70 months of incarceration under section 18 U.S.C. 922G1 for being a felon in possession of ammunition. Pursuant to Congressional Commerce Power, section 922G1 makes it a federal crime for anyone previously convicted of a felony to possess in or affect in commerce any firearm or ammunition, or to receive any firearm or ammunition which has been shipped or transferred in interstate or foreign commerce. Mr. Seekins had not purchased those two shotgun shells. He said that he found them in a dumpster, and he did not travel across state lines to actually come in possession of those items. Despite that fact, the Fifth Circuit held that his mere possession of those items was enough to sentence him to 6 years in prison. Mr. Seekins then argued for a petition on a rehearing that the application of section 922G1 against him is pretty much absurd on these facts and it's unconstitutional because it extends the Commerce Clause beyond what is permissible. 3 Fifth Circuit judges dissented from the denial of the rehearing, and they emphasized the unconstitutional implications of applying section 922G1 here in this specific case. But their concern was overridden by a 9-7 vote which ultimately denied Mr. Seekins a rehearing by the Fifth Circuit. In response to that denial of the rehearing, Mr. Seekins is now petitioning for the Supreme Court to take up his case and to review whether or not 922G1, as applied to him, is unconstitutional. Recently, the Supreme Court held that under the Commerce Clause, Congress can only regulate conduct that substantially affects interstate commerce or has another evident commercial nexus to interstate commerce. Here in this case, it appears Mr. Seekins is trying to springboard off of the 1995 landmark case, United States v. Lopez. In Lopez, Alfonso Lopez was arrested for carrying a concealed weapon into his high school. He was charged under the Gun-Free School Zones Act of 1990, a congressional law that banned people from bringing guns into school zones. It was essentially a gun-free zone kind of law that was put in place. Lopez challenged his conviction, arguing that the law exceeded Congress's powers under the Commerce Clause, because the Commerce Clause was the underpinning of that specific statute. In a 5-4 decision, the Supreme Court agreed with Mr. Lopez and struck down that specific law. This was the first time that the court struck down a law passed under the Congress's Commerce Clause powers since essentially 1937. In the end, the court used the Lopez decision to push back against some of the broadest assertions of congressional power under the Commerce Clause. In this specific case, Mr. Seekins is trying to use that same rationale to push back against the use of the Commerce Clause and how it is being used against him simply because he's a felon who was potentially in possession of 2 shotgun shells, and now all of a sudden he's spending 70 months in prison. In the petition, he argues that the unique factual situation involving just 2 shotgun shells found in a dumpster highlights the purely intrastate character of this case and the dramatic consequences of this law's application when compared to previous challenges to Section 922G. It's hard to imagine a more local crime than this. The facts of Mr. Seekins' case therefore squarely present the issue of whether Congress may criminalize purely intrastate activity, possession, based only upon the distant historical connection between the ammunition and also interstate commerce. Allowing Congress to categorize such possession as significantly affecting interstate commerce defies all logic and results in the extension of unconstitutional and essentially unlimited regulatory and police power to Congress. So this is an interesting challenge that will impact Second Amendment rights without bringing a pure two-way challenge. This one is primarily focused on interstate commerce. And there may be some Supreme Court interest in this issue, with the Supreme Court recently requesting a response from the government, which is due on May 22nd. The Supreme Court has shown some interest in the past on federal prohibitions and federal possession prohibitions, specifically relating to misdemeanor individuals, felony individuals, especially when you look at Justice Barrett in her prior Cantor dissent. She also wrote a dissent which hit on these issues, was really interesting. So she also specifically may be interested in this topic because she's addressed it before. But even more interesting about this case is the fact that it deals with the Commerce Clause and could be a similar vehicle for the Supreme Court to go back and revisit the other case that we just talked about, which was the Lopez case. The current Supreme Court has been fairly aggressive in revisiting prior precedent and strengthening or reversing that precedent. And this could be one of those situations where if they want, they could go back and revisit Lopez and kind of strengthen that decision with a new one here in this Seekins case. This could be a case the Supreme Court is interested in because of the strange facts that led to this specific lawsuit and just the dramatic impact that this one specific law that has the Commerce Clause as its underpinning is now essentially putting against an individual who simply is in possession of 2 shotgun shells. That's what he's been convicted of. He had to spend time in prison for because he was allegedly a nonviolent felon who was in possession of 2 shotgun shells that he found in a dumpster. Historically, the Supreme Court is much less hesitant to take up Commerce Clause cases, whereas they traditionally have been much more hesitant to want to deal with Second Amendment lawsuits. So this could be one of those cases where we kind of get a backdoor effect on the Second Amendment because it deals with something else. So this is a really interesting case, and now we will see how the government responds, what they argue, and ultimately we'll see if the Supreme Court wants to take up this case and wants to hear this issue. If we get any more information, I will let you all know. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.